Good morning, everybody. My name is Kate Nemens. I am an attorney with the Clubhouse Family Legal Support Project in Boston, Massachusetts. Okay, so this is me, Boston, Massachusetts. It's the legal project actually that Kim was talking about last night through Employment Options. That's me. I'm the lawyer that she was discussing. She and I met when she was doing part of her tour of the United States and Massachusetts. So the Clubhouse Family Legal Support Project is a grant-funded project, which means that we get money from a couple different sources, limited amounts of funds, unfortunately. And it's a collaboration between two different agencies, the Mental Health Legal Advisors Committee, which is an organization of attorneys in Massachusetts that works with individuals with mental health issues in a variety of different areas. And I am the individual there who works specifically with parents. And I'll talk a little bit more about the work that I do in a minute. Our two funders, the Department of Mental Health, which is the state agency in Massachusetts that provides mental health services. Not all of our mental health services, but sort of the point agency for mental health services in Massachusetts. And then a legal agency, the Massachusetts Bar Foundation, is our other funder. So what I do is I provide assistance to low-income parents with mental health issues who are seeking access to their children. So in Massachusetts, we have courts that handle juvenile matters, which is where the child is the subject of the proceedings, and then we have what's called the probate and family court. And the probate and family court is where divorces and custody disputes are litigated, and that is where I do the majority of my work. Sometimes there is some overlap in the juvenile court as well, so but my direct representation, the individual assistance that I provide is all to parents. I don't represent children, and that does make a little bit of a difference because an attorney's role is very client specific. That's true, and that can sometimes put up some barriers. Some of the barriers that some of our other speakers have been talking about, sharing of information, privacy concerns. Those are all really big issues when you're an attorney because your focus is on representing your individual client. So what's important to keep in mind for my work is that I'm specifically representing parents. I provide direct representation, brief services, and advice, which can vary in a variety of different ways, whether it's providing assistance in negotiating for parents, advocacy with our state child welfare agency, who many of my clients are involved with. We provide referrals to a host of different organizations. My agency is very small. We're made up of 8 to 10 staff members, I think 8 attorneys and a couple staff members, and we provide a representation for individuals across the entire Commonwealth of Massachusetts. So I am the only attorney who's doing this specific work with parents, so obviously I can't provide representation to everyone. We reject a large percentage of the folks who come to our agency for services, unfortunately. So we provide a lot of referrals to other organizations, but unfortunately in Massachusetts and actually across the country, there are very, very few attorneys who actually do this particular kind of work. The legal services set up in Massachusetts, as is true in most of the country, does provide representation in these kinds of custody disputes and family law cases, but most of the focus over the last, I'd say 20 years has been on working with victims of domestic violence, and while there's often a lot of overlap for these client populations, that's not necessarily going to be a factor in working with my particular client population. So it's sort of like an attorney on an island in a little bit for me in terms of doing this work. But there are the couple other attorneys who do this work are actually here this weekend, which is great. So we get to all connect with each other. So what are we going to talk about today? Identifying the legal barriers for parents and their advocates in the court system. Now again, I only practice in the Commonwealth of Massachusetts, and the laws in every state in the United States are a little bit different. There are some similarities. I'm going to try and speak as generally as I can, but when you're an attorney, you like to speak in specifics and be very accurate. So to some degree, it is going to be very much sort of looking at Massachusetts law, but I'm going to try and not be too specific since we have an international crowd here as well. We're going to learn a couple strategies, and again, these are sort of my 2 cents, and I welcome everybody's participation, and feel free to interrupt. I tend to go very fast, and we have a limited time, so you might have to kind of wave to get my attention, but feel free to do that. I'd like this to be a conversation as much as it can be. So strategies for advocacy to overcoming some of those legal barriers, and then just some thoughts about supports and resources for parents and advocates, and most of the time I'm learning more from the people in the audience about those supports and resources that I'm given, but just some ideas and some experiences that I've had that I've found have been helpful. Okay, so in Massachusetts in particular, the legal standard, what the judge is going to be looking at when making a determination about custody and parenting time decisions is going to be looking at something that's called the best interest of the child. And that's a pretty common standard that's used across the United States in terms of how a custody dispute might be determined. The laws are often meant to be child-focused. And that can be something that's very challenging for when you're working with parents with disabilities, parents with mental health issues, because my clients often feel a great degree of frustration in feeling that, but I'm the parent, and why are we always looking at what sort of is wrong with me and what the failure here was. And the challenge is that the court's response often is, but I have to look at what's best for the child. It's not about what mom wants or what dad wants, but it's about what the court believes is best for the child. And that, the discussion earlier this morning about balancing protecting children and having child-focused laws and recognizing the needs of parents is often in conflict in the legal system in particular. We also have other kinds of cases which are referred to as guardianships in Massachusetts and in many states, very similar, which means that a non-parent, so a grandparent, a cousin, a neighbor, somebody else, some other third person is caring for a child. There's a different legal standard in that kind of a case, which is similar to the child welfare cases, which is when the state has intervened to take custody of a child as opposed to a parent. And in those circumstances, there is a different standard, and a parent actually has to be shown to be currently unfit in order to lose custody of their child, as opposed to it just being a best interest standard. So there are pros and cons to dealing with these different kinds of cases and dealing with these different legal standards, and both of them can present challenges. So for example, the best interest of the child standard is very broad. You can sort of use a lot of information to try and convince a judge that this is something that's in the best interest of the child, or this is something that's not in the best interest of the child. You can get a little more creative when you're dealing with two parents who are on equal footing when you're talking about the best interest of the child, as opposed to in a guardianship case or a child welfare case where you're talking about one particular parent's unfitness versus the state interest in protecting a child, or versus the guardian's interest. So it's actually, in a sense, depends on which way you're looking at it, but sort of a lower standard in order to take a child away from that parent when you're talking about the state or a non-parent, as opposed to two parents on equal footing. These are the kinds of cases that that I provide representation in. Although again, as I said, not as often the child welfare cases, and that has to do with the legal setup in Massachusetts. Okay. One of the other aspects that come up in all of my cases when dealing with low-income parents with mental health issues is the challenge of focusing the court and focusing the players on what is the parent's actual ability to care for their child, as opposed to the sort of red flag of a mental health diagnosis. What often happens in these cases, they're coming in at a time of crisis. A parent has been hospitalized, or there's been some sort of an incident, and somebody rushes into court saying, I've got a parent with bipolar disorder who's not taking her meds. Oh, well, of course we need to remove that child, and we need to put all these protections in place, and there needs to be sort of a crisis reaction. I had a friend of mine once say that we sort of provide representation. We're like the ER doctors of lawyers. We're the emergency room, version of attorneys in a lot of these cases, because there's been some sort of crisis and everybody feels the need to sort of dive in. And one of the biggest challenges that I think, in our cases and the parents that we work with is this playing of the diagnosis without any sort of examination of an individual's symptoms, an individual's capacity. There's no discussion of strengths. There's no discussion of a parent's resilience. There's none of this sort of lovely examination that we've already heard so much about in the short time that we've been here. It becomes, the law often is this very blunt instrument. And so most of my job is spending a lot of time doing this sort of individual analysis, looking at this individual parent. Is the challenge that they have to take a medication in the morning that makes them really tired? So is it really difficult for them to get up with their kid in the morning and get them dressed and get out to school? Okay, that's a very concrete issue and a very solvable issue, and something that just requires some assistance, maybe a change in medication, maybe somebody makes a phone call in the morning to wake mom up so that she can, I mean, these are solvable problems, but you have to be able to get into that level of detail with the individual cases, as opposed to just taking a broad look and say, oh, we've got a mom with bipolar disorder, takes medications that makes her sleepy, she can't get her kid to school. And then the other challenge, and this is true in a lot of different states, but particularly in Massachusetts, we have some pretty strict time standards and rules about how these cases are supposed to happen. Once something initially gets filed and gets into court, there's supposed to be a particular timeline, and those a particular timeline for when the case is supposed to resolve. So what that means is that the courts are trying to consider what's going to be in the best interest of a child. If you're removing them from their home, can we keep that removal period as short as possible? If you're making a change between living with one parent to the other parent, you know, what is going to be, what is going to ultimately result in permanency for the child sort of as quickly as possible. And while I think those are all child-focused ideas and very important when you're thinking about it from the perspective of permanency for a child, that often really that's in direct conflict with recovery time periods for parents dealing with mental health issues, because as we know, that recovery trajectory often includes relapses, and sometimes they can be significant and sometimes they can be minor, but you're not always moving sort of in one particular direction and one positive sort of upward slope direction for that recovery. And so that can really, you're often sort of in a time crunch. We're always trying to sort of move things along so that, you know, for example, if a parent comes to me and they've lost custody of their child and they're only having parenting time that's supervised, for example, let's say 1 hour a week, which unfortunately is very common for my parents once there's been some sort of a crisis. If that's where we're starting, my goal is to get them moving forward in terms of their time as soon as possible, because the longer time period that they're stuck in that limited access to their child, the more harm there is to the relationship, the more harm there is to their recovery potentially, because this is often a motivating factor for folks, obviously, that they want to regain connection with their child. But you know, one of the biggest issues for our parents is how do you move your recovery process along at lightning speed? It doesn't work like that. You know, these things often can take time, and as I said, sort of include the relapses. So that's a big challenge that we're dealing with. Yeah.
I'm just wondering, when you're describing this, do you ever use what is sometimes termed the Ulysses agreement, where the parent would have, before they became ill, a pre-identified plan?
Mm-hmm. Yeah, so we don't have a Ulysses agreement per se in Massachusetts, but we do have the option of a caregiver authorization form. There's a form that you can fill out to authorize somebody to take care of your child. We do, you know, the challenge is, as sort of being the ER version of attorneys, is we come in after the fact to do cleanup. I'm very rarely working with folks before the crisis occurs, and that is a big challenge. So that's one of the reasons why I do these kinds of presentations and try and talk to people about planning in advance, and that is one of my strategies. So thank you for bringing that out. But yes, you know, to try and make plans ahead of time for folks. Once they're involved with good systems of care and good teams of providers, that usually does become a part of their overall plan, a part of a parent plan, which makes perfect sense. For somebody with a chronic physical illness, you're going to do the same thing. You're going to do healthcare practice in advance. You're going to do planning for where your kids are going to go and figuring out your estate. And if you know that there's the potential for a crisis or a hospitalization or some sort of issue, you're going to want to make plans for your kids as well. And those, you know, can sometimes be honored, and other times you've got to, you know, these are fractured families. And so sometimes you've got folks on the other side who are a little less understanding about these kinds of situations. So planning is great. It doesn't always work out, unfortunately.
How do you make sure that something like that's honored? Because we're working on a RAP project right now, and we want to put psychiatric advanced directives inside people's case plans. How do we make sure that they are honored and upheld?
Well, so that's the challenge, and I think that's going to be dependent on the laws in each individual state. Because, so for example, So there are oftentimes these plans that you can put into place, and they can be legally enforceable, but not necessarily legally enforceable, and that's gonna depend on the state. So for example, the caregiver authorization in Massachusetts, it's enforceable in the sense that somebody with that piece of paper can enroll a child in school, they can get them to their doctor's appointment, they can provide all of the care that they want. But if the other parent comes in, or another individual, let's say a grandparent, wants to file a guardianship petition, meaning for them to get custody of that child, they can still do that, and the court has the authority to make orders above and beyond that determination that the parent made in advance. And sometimes that's because you're talking about two biological parents, so one's right to make decisions for the child is not necessarily superior to the other. And other times you're just talking about a grandparent, let's say, coming into court and saying, well, but that wasn't enough, and that was temporary. So in Massachusetts, the caregiver authorization can be revoked by the parent at any time. So I've seen conflicts where that works for a little while, and grandma and her daughter are getting along, and the daughter says, I need you to take care of my child for a little while. And then they say, you know what, I'm done, I'm ready to take my child back, and grandma doesn't agree. And then she can go into court, and now you've got a legal battle, and you're kind of back where you started. It's unfortunately a frequent occurrence. Yeah.
You mentioned that when it's parents and when it's the court and one unfit parent, the standards are lower. What does that mean? Does that mean that?
So the legal standard of best interest of the child has two parents who are on equal footing in conflict with each other potentially. So in looking at both parents, that standard is applied equally to the two of them. When you're dealing with the state having custody of a child versus a parent, the lower standard of unfitness, meaning there's a lower threshold that the state has to show in order to, well, so depending on how I'm talking about it, it's either lower or higher. So from the parent's perspective, they do not have to be as capable. That's a terrible way of putting it. The parent just has to be shown to be currently fit to take care of their child. They don't have to be shown to be a good parent. I mean, this is fortunately a way that we talk about it often. They don't have to be a good parent. They don't have to be a great parent. They just have to be an adequate parent. And that's the burden that the state has to overcome, meaning that the state agency has to show that they are not even fit to take care of their child in order to keep custody. Does that make sense? Sorry, legal terminology doesn't always translate to everybody else, and I have a tendency, the way that the acronyms get used by the providers. I use my legal standards, and I assume everybody knows what I'm talking about.
I just right now that I know a child, his name's Noah, and he was taken from his parents with part of it being mental health issues and a domestic violence situation. And the state now wants to give him back to the mother because she just got put on welfare. But then on the flip side, I know the individuals who got the child from the mother, and they're now throwing out all, they're angry. And they're angry that the judge is saying, bring her back, because they're saying, well, she's low income and she's not a two-parent household, and look, we're so much better.
Right, but better isn't the standard in those situations. If it was between two parents, better can do it. One can just be better than the other. But when you're talking about the state intervening, we do still have laws that are favoring children remaining with their parents in those circumstances. And so the state, the parent just has to show that they're fit. And that doesn't necessarily always mean the best parents. And that's what sometimes makes those cases really challenging, because I look at them and I say, but we can make the situation better. I'm not saying the parent has to be, nobody's a perfect parent. I mean, let's be honest. Nobody's a perfect parent. Nobody needs to be expected to be a perfect parent. But the examination, the challenge with the legal system, and this is much broader than what we're specifically talking about here, is that there isn't necessarily an examination of what kind of services and supports can we put into place to make this whole situation, sort of raise the level of the whole situation for the parents, for the children, for the family as a whole. We're just looking at blunt instrument legal standards. Is it fitness? Is the parent fit to take care of this child? Can they get them out of a burning building? Okay, so then there we go. And that doesn't provide any support afterwards. That doesn't really change the family dynamic. Unfortunately, for a lot of these families, and I'll be talking about this later, the biggest obstacles are poverty. In addition, layered on top of dealing with mental health issues and other systems, housing and transportation and all of the things that come along with being in a low income or a very poor household. And so that, all of those things compounded, really makes these situations cry out for supports and not just litigation and legal intervention, which is, again, sort of this blunt instrument. So, I mean, I don't think, I'm talking to an educated audience on this. I don't really need to say much about the stigma and bias. That's very common. Our judges are not always well educated, or even just not knowledgeable. This isn't necessarily a training area. I've done a couple trainings for judges here and there, but it's not an area that judges are necessarily trained in from this perspective of how can we provide supports to these families, how can we identify strengths and recognize resilience in these families to make things function better for parents and for children, as opposed to just sort of knowing diagnosis and understanding medications a little bit, which is usually where the training typically is for judges. So there is sort of that bias against the idea that a parent with a mental illness just isn't as capable as somebody who doesn't have mental illness, for example. So there's a lack of standardization and specialized knowledge, minimal training, limited exposure to the recovery model, peer supports, alternative and complementary treatments. That's just not discussed. When I go into court, the judge wants to know, is this person in individual counseling? Are they taking their meds as they're supposed to be taking their meds according to whatever doctor who saw them for 15 minutes is telling them to do? And do they, who cares if it makes them tired in the morning or makes them gain 30 pounds or, have dry mouth or the dyskinesia, whatever the symptoms are, if you're supposed to be taking your meds, that's what I expect. I've had that written into court orders, probation conditions. It's, again, it lacks an individual analysis of what might work for a particular family. It lacks an understanding of what other kinds of alternative treatments are out there and alternative models are available. One of our sort of great success stories in our office was a young man who had a young daughter who was diagnosed with bipolar disorder, and when he got sick, he got very sick, and sort of would have always law enforcement intervention, would sort of end up on the street, maybe not wearing clothes, screaming and yelling. I mean, really sort of dramatic crisis events. He did not want to take traditional medications. He was very adamant, very concerned about what he was putting into his body. And rightly so. As we know, a lot of these medications can have really debilitating side effects. And it took a lot of work and a long time, and he is now avoided, and he always had hospitalization, so it was criminal intervention, it was hospitalizations, it was all these sort of crises, and it was happening repeatedly. But he found some alternative treatment modalities that really worked for him, and he now functions fabulously. He hasn't had a hospitalization in years. It took time, and these legal cases don't always allow for that. But we were able to convince a judge that with some other protections in place, that, to make sure that if he had an incident or an episode when his daughter was with him, that there were some protections in place for her, with those in place that he could move forward without necessarily being required to engage in treatment that he didn't want to engage in, which an individual should be able to decide on their own health care. Okay, so again, we talked about how the recovery process and the timing can be really challenging. For a lot of our folks, there are a lot of delays in treatment and services due to cost, due to insurance, and the American system coverage is not what it should be, and not for, unfortunately, what a lot of our folks are dealing with are long wait lists for providers, particularly if somebody's looking for a specialized provider, or sometimes even just an individual social worker to do weekly therapy. And that can delay parents' engagement in services and engagement and recovery process, which can really prove to be a problem with the time frame of the case. Okay. So attorney-client relationships. There aren't a lot of attorneys who necessarily have experience in this area either. I sort of fell into it and have now been doing it for 10 years, and it's really only by practice and engaging in conversations like this and working with providers that I've gained any sort of knowledge. But it doesn't mean that I don't experience bias, and that other providers working with parents with mental health issues are experiencing bias as well. And so that makes these can be really difficult relationships for the parents to navigate. an attorney is sort of viewed as the gatekeeper of the legal system, and I'm supposed to know how to fix everything, and I'm supposed to be able to tell an individual what all of their rights are. Well, it's never that simple. If you ever ask an attorney, what about this and what about that, half the time your answer is going to be it depends, and it always does. And I say that a lot. And so, one of the challenges is attorneys who don't have the expertise, who are trying to provide assistance to these parents, or a lack of attorneys, because these parents are not entitled to representation in the cases that I work on, meaning most of these cases parents are proceeding by themselves in court, because there's only one of me in Massachusetts. And there's also a lack of the resources that are out there. We've talked about how there can be pockets of expertise and pockets of excellence, and that's true in individual states and across the country and across the world. And so sometimes I'm not even aware of the resources in other parts of Massachusetts, much less around the country. And again, sort of the limited access to attorneys for parents. It's only in the child welfare cases when the state is actually involved that they're entitled to representation. Otherwise, as I said, they're often proceeding by themselves. And then this idea that, these parents, we talk about the peer model being so successful. My individual clients are responding to human connections, and I'm supposed to be this sort of gatekeeper of the legal system. And I like to think that I spend a little extra time trying to connect with my clients, but that's not how all attorneys operate. And as a profession, we're supposed to divorce ourselves from emotion and connection, and we're supposed to focus on the law and the rules, and that can often be in conflict with working with individuals in these very emotional cases. I'm talking about their kids. Who doesn't sort of have a human connection around that? Yeah?
In relation to this, and one of the reasons that I came in here, I voluntarily went into psychiatric inpatient care after my son was born, voluntary, and I had zero history of child abuse, zero history of it. My husband advocated for them to let me see my son for anything, so they never even saw my son because they refused to let me see him, refused my husband. But they called DHS the moment that I arrived in psychiatric inpatient care and did not inform us until the last day that I was leaving that they had removed my child from me. And I had to fight to try to get my son back, and it ended up being unfounded by the state. And then the other thing that had occurred is while I was in there, a social worker in the psychiatric inpatient care pulled me aside in the hallway and told me, if you ever end up back here, and I did not go in with attempted suicide, and she told me, if you ever end up back here or you attempt suicide or anything, I guarantee your child will be taken away for good. So I was threatened by a social worker in the hospital. I pursued a grievance process with the hospital, and it went nowhere. The grievance process just went to a letter that said, well, we individualize care for everybody, and our mission is this, and we're doing the best we can.
Unfortunately, I don't think that's a unique circumstance. We hear a lot of my clients are very frustrated. They don't have a history of causing harm to their child. The mental illness, the identifier of having a mental health condition becomes the quote harm. And again, that's without this analysis of what is actually going on. How are we talking about the harm of the mom who just can't get up in the morning and get her kid to school? Is that harm? No, that's a solvable problem that, first of all, a lot of parents have. I know I have that. So, the challenge always is, can we see beyond the stigma and the label of the diagnosis, and can we look at how a family is actually functioning, identifying the strengths and identifying the resilience. The fact that your husband was advocating for you to be seeing your son is actually surprising to me, because usually I'm dealing with fractured families where you have the parents pitted against each other. Typically in the intact families, or sometimes in the intact families, you might have a little better success. I'm going to just keep speeding along a little bit because we're very short on time. Talked about some of these limitations that the parents that my clients are dealing with as a result of poverty. So strategies for advocacy. Okay, talked about this. Working with parents, not just, so for attorneys, when I do trainings for attorneys, I often say to them, okay, get out your diagnostic manual, look at the diagnosis, get a sense of what the general, typical, symptoms and medications and side effects, and just get a sense of sort of the landscape for your client. That's not necessarily individualized, okay? That's the general picture of a particular diagnosis. What does it mean to have bipolar disorder? But if you're starting at square one and you need to learn a little about this, that's a place to start. But then you really need to get into your individual client history, their recovery process, their present functioning. How are they actually functioning as a parent? again, this analysis of the individual parenting abilities, and particularly in relation to this individual child. If you have a child who's got special needs, if you've got a child that doesn't, that may make a difference in how resilient they are in terms of managing within the family. And then the importance of learning about your client's providers and the supports and services and tools that they have available to them that are available in the area. I think that one of the really important things that I try and do in talking with my clients, because I like to think that we can overcome everything, but everybody's going to be in a different point in their recovery. Every parent's going to function a little bit differently, and so we often spend a great deal of time talking about what our ultimate goals are and can we redefine success. Are we just talking about sort of winning in a legal case, and what does that mean? Or can we just talk about when you want to see your child, how you want to spend your time with your child, what the nature of your relationship with your child is going to be after this litigation is over, and how can we reach that result, which isn't necessarily about sort of winning your case. And I know I'm out of time. I want to put up this last slide. I think that's and I apologize for running out.
Always happens, so you have a lot to say, and people can connect with you throughout the call.